Good morning, everybody, and welcome to another episode of Monday Morning with Mo. I am Attorney Mo DeWitt here to answer all your legal questions every Monday morning at 8 a.m. You can always give us a call, leave a voicemail, 407-536-6737. If you do try to call right now, I'll try to figure out how to get you on live. I haven't really figured that out yet, but we'll give it a try. Otherwise, you can always email us, ask@dewittlaw.com. You can also text that number, 407-536-6737. So multiple options to get your legal questions answered. Let me adjust this mic here a little bit. Maybe that's better. So yeah, if you have any legal questions, that's what we're here to do every Monday morning. Give you some free legal advice to get your week started off right. So I hope everyone had a great weekend. Had some pretty good weather on Saturday, a little hotter on Sunday, but still hope you had a good weekend nonetheless. And let's get to it. So let's see. First question is from Brian from Brevard County. I've always wondered why law enforcement officers, Leo, in quotations, or in parentheses, issue citations for crashes in Florida if it's no fault. Crash reports also list vehicle 1 as the at-fault vehicle. I'm confused what the difference is. Also, if crashes occur and both parties have the same insurance company, is it still required to report? I understand the FRS on crashes requires certain conditions for mandatory reporting, but I do not understand how Leo law enforcement officers fault a driver when it's a no-fault state. All right, great question, Brian. So while Florida we have no-fault insurance, we're not a no-fault state. So no-fault insurance, which we've talked about before, is your PIP insurance or your no-fault insurance. Let me get a drink here. Got to get that morning coffee. So we do have PIP insurance in Florida. Personal injury protection. It allows you, if you're in an accident, it allows you to get up to $10,000 in medical benefits for that accident, whether you're at fault or not. However, they still list vehicle 1 as the at-fault vehicle because the person who's not at fault still has a claim against the person who's at fault. And that's a general negligence claim, an auto accident negligence claim, because that person was negligent and caused injury to another. So the insurance companies, instead of having a mandatory bodily injury requirement in Florida, which is basically if someone hits you and hurts you, that's what the bodily injury damage is for. So on your own policy, if you hit and hurt somebody else, you have a bodily injury insurance that's supposed to cover those damages. Now in Florida, you're actually not required to have bodily injury coverage. All you're required to have is $10,000 in property damage coverage and your PIP, your $10,000 in PIP. So that's why we have no fault benefits in Florida, because we don't have minimum BI coverage. So that's what it is. We're not a no fault state. We do have no fault insurance. So whether you're at fault or not at fault in a car accident, you can still go get medical treatment if you're injured. That's the purpose of that. A lot of people don't realize that they can use that even if they're not at fault, but that's what it's there for. But we still are an at fault state. If you hit someone else with your vehicle and injure them, they can file a lawsuit against you to go after your insurance company or even you personally, which is why it's important to make sure you have enough insurance coverage there to protect you and protect your assets, as well as if you don't have sufficient insurance coverage, your license can get suspended as well. So very important to make sure that you have sufficient insurance coverage. So I hope that answers your question there, Brian. I thought there was one other part of the question there. Oh, also, if crashes occur and both parties have the same insurance company, is it still required to report? Well, yes. I mean, if you want to make a claim through your insurance company, whether you both have the same insurance company or not, you still are required to report it. And so I talked about this in one of the videos that we posted on Facebook a few weeks back. So if you both have Geico or both have Progressive or Allstate, whatever insurance company it may be, when you're dealing with them, you want to make sure you know who the adjuster you're speaking to represents. Because essentially what happens when they both have the same insurance company is kind of a wall goes up, an artificial wall goes up. The insurance company saying, all right, adjuster 1, you represent this party, adjuster 2, you represent this party. So even though they're the same insurance company, they're operating like they're separate insurance companies. So when the adjuster calls you and says, hey, I'm calling from Geico, and they don't say who they're representing, if they're representing you or the other driver, you want to make sure you clarify that with them so you know who you're talking to, and make sure that you understand the relationship that's going on. But it happens all the time. People with the same insurance company get in accidents all the time, and that's basically the way it operates. So, yes, you still want to report it if you're going to make a claim. Still required to report it. But when you're speaking to the insurance adjuster, you do want to clarify, who they're representing in that accident, so that is clear. So, great question, Brian. Always appreciate it. Again, crumple up for effect there. If you have any legal questions, shoot us an email, askask@dewitlaw.com. I have the phone number where you can call and leave a message at the bottom of the screen, 407-536-6737. You can also text that number. Always happy to answer your legal questions and help you guys any way we can. And it's always kind of fun, too. So it's a fun way to start your Monday. So let's go to the next question. No voicemails this week, unfortunately, just email questions. Give me 1 second. Gotta hydrate with some more coffee there. All right. Hi, Mr. Moses. How are you? I owe over $1,600 in tolls to EPass, and my registration is on hold, so I can't renew it. Can I forfeit my plate and get a new one instead, since the tolls are registered under the plate and a registration that's on hold? Thank you. Not something I know off the top of my head, but I'm going to go ahead and guess probably not. I'm going to guess those toll violations are probably linked to your driver's license somehow, and if you don't pay them, eventually they'll probably suspend your driver's license. Whether you could trick them for a short period of time and forfeit the registration and get another one, that might work, but it's going to catch up with you eventually. So I'd recommend trying to make some sort of payment arrangements with them, or reach some sort of agreement with them to get that resolved there, because ultimately you could end up in court for those. Your license could be suspended. There could be other penalties, other issues. So you probably want to get that taken care of. I don't think just forfeiting the plate is going to solve the problem there for you. So good question, I guess. Stay out of trouble. Stop running tolls. But I don't think forfeiting the plate is going to do it on this one. I wish I had a better answer for you. I wish that there was a magic solution, but I don't think that's going to do it. I think that might end up getting you into more trouble than you want to get into. So, best of luck. If you need anything else, give me a call. But yeah, I would definitely contact them, try to work out some sort of payment arrangement. The sooner the better, honestly. So that your license doesn't eventually get suspended. You don't end up in court. All that kind of fun stuff. All right, let's see. Next one here. I was recently in an accident. The accident obviously impacts my vehicle's value negatively. That being said, will this depreciation hit be included in the settlement amount? I have a feeling the car will never be the same, even though I owned it for less than a month before the accident, and will more than likely look to replace it. All right. So anytime you're in an accident, if the vehicle is not totaled and you don't lease the vehicle, you want to make sure as part of any settlement claim that, of course, they're going to repair the vehicle, but then you have what's called a depreciated value claim. Basically, your vehicle is depreciated in value, so you have a right to be compensated for that. It's a pretty simple theory. So if you go on the resale market and you purchase a vehicle that's been in an accident is worth less than a vehicle that's not been in an accident. So that's the depreciated value that you're asking for them to make up as part of the settlement claim. Now, it doesn't apply to a lease vehicle because a lease vehicle you don't own. Excuse me. And of course, it doesn't apply to a vehicle that's totaled because they're paying you out for the totaled value. There's no resale of that vehicle, so it doesn't really apply. Just from personal experience, the insurance companies are really sticklers about the depreciated value claims. They really don't like to pay out on them, but you can, if you include it, you can always get something for it typically. But we've really had to fight them on the amount. And we've gone back and one of the kind of tricks that we use is we'll go in and list in detail all the features on that vehicle and submit it to one of these companies that gives you an instant quote. And we'll do one for a vehicle that hasn't been in an accident versus one for a vehicle that has been in an accident. And then submit that to the insurance company to show the difference in the vehicle's value. Because it does make a difference. You're going to go resell that vehicle. Accident wasn't your fault, I'm assuming. And so why should you not be compensated for that depreciation in the vehicle's value when, again, it wasn't your fault? So great question there. Always appreciate it. And if you have any more questions, shoot us an email. ask@dewitlaw.com. I hope you guys are enjoying this stuff. Just kind of trying to answer some questions every Monday morning. Hopefully you guys find it interesting. I'll keep doing it until nobody watches anymore. I guess I don't know. I don't know. We'll keep giving it a try and see if see what kind of feedback we get. But if you are enjoying it, drop something in the comments. Let me know. If there's anything we can do to help you as well, let us know. Just so you guys know, it's October 19th now. So still a couple months away, but we are going to be doing an end of the year party for all our newsletter subscribers at FunSpot. So if you're not a subscriber on the newsletter, go to our website, go ahead and register for that, and you'll get all the information for the FunSpot party. Should be a great time. Free admission to FunSpot, free food, free non-alcoholic drinks, and just great day with the family. Come out there, enjoy it. I know it's been a hard year for a lot of people, so hopefully we can end the year on a high note and have a little fun. So if you're not receiving our newsletter, go ahead and do that, because the information for that will be in the upcoming November newsletter, which should be shipping out here pretty soon. So I think you can register on our website, dewitlaw.com, or maybe even justcalmo.com has it as well. But if you can't find it, shoot an email to ask@dewitlaw.com, and I'll point you in the right direction. But it should be a good time, so hopefully you guys will join us. Let's see, we got one more question here, and then I'll let everybody go about their morning. If you've watched to this point so far, thank you very much. I'm glad you're enjoying it, glad you're watching with me. So let's see, this one... Oh, this is the same one that we did earlier. So, I guess that is all the questions for today. Yeah, this is the one about the at-fault vehicles. So yeah, we already answered that one this morning. Oh, no, there's one stapled to the back of it, sorry. Another one from Brian. Different Brian, though. Yeah, different Brian. All right. So, here's my situation. A few years ago, my father applied individually for a retail credit card. After a few months, I left the name of the store out because I don't want to be able to anyone to identify him. After a few months, he added me as an additional user, giving me my own card. I did not provide my social security number, income, or any other information, and neither did he, other than my name. Since then, the retail store has switched the credit card company they use and shut my father's old account off, which was in good standing. Now the previous card company is coming after my father as well as myself. Even though I provided no information other than my name and agreed to no terms, am I on the hook for the debt on which is being reported on my credit currently? So you said the account was in good standing. So typically what I've found with these kinds of cases, it's usually only the account holder who actually agreed to the terms of the credit card who would be legally responsible. Now, that being said, you want to make sure he didn't check some box for your name, making you legally responsible as well. However, with the actual reporting to the credit card agency, what I found with prior clients is if you go into each credit reporting agency and report to them that this was not your card, that you were just an authorized user, typically they will remove that off your credit report. But you have to go into the 3 credit reporting agencies directly, go ahead and flag that, say, hey, this was not my card, had nothing to do with it, never signed on the user agreement, and they should remove that off your record, off your credit. I've seen that work for clients in the past. From a legal perspective, if they filed suit on that, it's a breach of contract, essentially. They sue under two counts typically. First one is breach of contract, second one is unjust enrichment. You obviously wouldn't be liable on the breach of contract action because you did not enter into that contract. They could try to get you on the unjust enrichment action. I think ultimately you could probably get dismissed if you fought it. But if they do file suit, give us a call, point you in the right direction on that. But typically, since you didn't sign on that user agreement, you shouldn't be liable on the breach of contract. If you were actually using the credit card, swiping it, signing for it, then they may be able to get you on the unjust enrichment count, which unjust enrichment is basically you were unjustly enriched by, in this case, taking goods without paying for them. And that's why they could sue you for unjust enrichment, even though there wasn't a actual formal contract between the parties. So I hope that helps, Brian. If you have any other legal questions, shoot us an email, ask@dewitlaw.com. You can always give us a call, 407-536-6737. Do that anytime during the week. If you think of something, leave a voicemail. We'll play